The general domestic violence restraining order court process. The process to obtain a domestic violence restraining order varies somewhat in each county and court, but the general steps in the court process are the same. Plaintiff's application. When a plaintiff asks for a domestic violence restraining order in family law court, the plaintiff must file court forms telling the family law judge why they want a domestic violence restraining order and what other related orders they feel they need. There are no filing fees for filing a domestic violence restraining order. Temporary orders. The family law judge will review the application for restraining and related orders requested by the plaintiff and decide whether or not to grant temporary orders that day or by the next business day. If the judge grants the temporary restraining orders requested, these temporary orders will only last and be in effect until the court date on the permanent orders. A judge may turn down the request for temporary orders because the plaintiff did not submit enough supporting evidence. If the family law judge does grant the temporary orders, the judge will set a hearing date on the request for permanent orders. If the family law judge does not grant the temporary restraining order, the family law judge will normally set a hearing on the request for permanent orders on the assumption that the plaintiff may be able to still make his or her case at the permanent restraining order hearing. These temporary orders can include orders on the following issues. 1. Stay-away orders. 2. Custody orders. 3. Kick-out orders and other property use orders. 1. Stay-away orders may order the restrained person to stay away and have no contact with the protected person, as well as the party's children and other protected people and family pets. 2. Custody orders may give the protected person sole, legal, and physical custody of the minor's children. 3. A kick-out order may order the alleged perpetrator out of the family residence. And 4. Property orders may state who can use the family home or the family car going forward. At the hearing on the permanent restraining order, the family law judge will normally, as stated previously, issue a date to hear the request for permanent restraining orders. The court date for the permanent restraining order will be on the front page of the domestic violence order form. The court date will be between 21 and 25 days from the date of the temporary restraining orders. If you are the plaintiff in a domestic violence restraining order case, keep a copy of the temporary restraining orders at your house, in your car, and on your person. This way, if the restrained person, i.e. the defendant, violates the temporary restraining orders, you will have a copy ready to show law enforcement personnel. Service on defendant. The plaintiff shall coordinate through the sheriff's office or law enforcement or professional process server or a third party to have the defendant, the party to be restrained and alleged perpetrator, with a copy of all court papers for the domestic violence restraining order and supporting papers. The judge will order a deadline for the plaintiff to serve the defendant with the domestic violence restraining order paperwork prior to the hearing. The judge can extend the temporary restraining order at the permanent restraining order hearing if the defendant has not been served or has not been timely served. Service on the defendant must be made by a person or someone 18 or older and not involved in the case. The process server must hand deliver a copy of all the paperwork to the restrained person. The person who performed the service of process must fill out a proof of service form and submit the original signed proof of service form for filing with the court. If you are the plaintiff, keep a copy of the proof of service filled out for your records. Filed with law enforcement. Have a copy of the temporary restraining order filed with your local law enforcement department. This way, the law enforcement will already be informed if the restrained person violates the temporary restraining orders. response. The restrained person, also known as the defendant, has the right to file a response to the request for restraining orders filed by the plaintiff, explaining the defendant's side of the story. The defendant can submit witness declarations, police reports, photographs, and other supporting material as evidence to the court proving his or her side of the case. Court hearing on the permanent restraining orders. Both the plaintiff and the defendant must attend the court hearing on the permanent restraining orders. If the plaintiff, the protected person, fails to show up at the hearing, the temporary restraining orders will automatically terminate that day, and there will be no restraining orders in effect going forward. If the defendant, the restrained person, does not appear at the hearing, he or she will have no input in the case, and his or her side of the story will not be taken into account when the family law judge makes a decision on whether or not to issue a permanent restraining order. At the hearing, the family law judge will decide to continue or cancel the temporary restraining orders. If the judge decides to extend the temporary restraining orders, the permanent orders may last up to 5 years. If the family law judge makes other orders in addition to the restraining orders, such as child custody or child support orders, these orders will have a different expiration date and will usually last until the child turns 18 or 19 or a family law judge changes the orders. Procedures for domestic violence restraining order overview. 1. File for a domestic violence restraining order and request for temporary restraining orders. 2. Temporary restraining orders are issued by the family law judge. 3. Service on the defendant with all the domestic violence restraining order paperwork. 4. Hearing on the permanent restraining order. 5. Permanent restraining order issued by the family law judge up to 5 years. 6. Plaintiff requests that the permanent restraining order be reviewed before expiration. Renewing a permanent restraining order before expiration. The plaintiff can file an application to renew the restraining order just before the restraining order expires. The family law judge will renew the restraining order if the plaintiff has a reasonable apprehension of future abusive conduct. At the renewal proceedings, the family law judge has the following 3 options. 1. Deny the renewal. 2. Extend the restraining orders for 5 years. Or 3. Make a truly permanent order that lasts forever. The family law judge can only issue a renewal for 0 to 5 years, but nothing in between. The takeaways. A domestic violence restraining order normally has 3 steps. 1. Obtaining an immediate but temporary restraining order from the date of the application at the family court to the date of a hearing on the permanent restraining order. 2. Coordinating with a third party, normally law enforcement, to serve the domestic violence restraining order paperwork on the defendant. And 3. Attending the hearing on the permanent restraining order. If the judge grants the permanent restraining order at the hearing, the restraining orders will last up to 5 years. Have any questions or suggestions? Leave them in the comments below. Please like and subscribe for upcoming videos. For free resources such as attorney referrals and legal checklists, please visit our website, utkdivorce.com. And thank you for watching.